So first, I'm just going to tell everyone about our upcoming events. Well, first I should say thank you all for being here today. It's lovely to see you all, especially as there's been a little gap over the summer. We'll be back with a few events now before Christmas, say the nasty C word already. So I just wanted to remind you of what's coming up. So our main event, our last big event of the year, is the 8th of October, and that's about the unexpected pressures of being a PA employer. So whereas today is more about the practical and legal side, this will be more about the mental health, the well-being, all the added bits that people don't really talk about but are so important. Thanks, Teresa. I'll fix the link in a second, sorry. The second we've got coming up is the 20th of October, which is our last webinar of the year, which is the state of direct payments with the National Direct Payment Forum. And I think this one's going to be really interesting because it's going to be looking at how direct payments were first set up, how people thought it would be, and how it has become in reality sort of over time. And Pat, who's doing that one, is a really, really interesting speaker, so I think that would be a good one. We also have one more peer support session this year, and I'll put the link to all of these in the chat, and I'll fix the slides, don't worry. But I will now pass across to the lovely Rachel, who's here today to speak to us about the webinar. So thank you, Rachel.
Hi, everybody. Thanks, Jade. It's really good to be here. So I'm going to tackle a few issues today concerning managing PA behaviours and have a look at some of the legal rules. Now, I'm not familiar with the people who are here in the audience and how confident you are as employers, how long you've been an employer, or what you know. So I'm going to try and cover off some initial basics and we can go from there. I'm going to try not to talk for too long. Going to try and keep it to no more than half an hour, and then there'll be loads of time for questions and answers and just general discussion once I've finished going through these slides. So bear with me and we shall get on with it. Okay, so the goal today, our objectives, is to give you the opportunity to be equipped with some actionable strategies, some legal knowledge, how we can perhaps resolve common issues that arise with employees, manage behaviours as professionally as possible, whilst also staying compliant with employment law. So, starting place is to understand your role as an employer. Now, it is not uncommon for me to hear. I've been talking to individual employers for many, many years, sort of going on 15 years, I understand I've been doing this role, as well as having actually been an employer managing a direct payment myself for a family member. So it is really not uncommon for me to hear that employers are saying, I didn't ask for this, I didn't know I was going to be an employer, I didn't understand what I needed to do. So it's making sure that you are initially really familiar with the fact that when you have a direct payment and you employ staff, even if it is through a managed account, you will be the employer. You are responsible for your own decision making, for the recruitment, for the training, and so on. There may well be great support mechanisms around you, support teams, social workers, whoever it may be. You may have a great support system, but fundamentally, you are the one responsible for the employer duties and for managing your own staff. So that means that you are under an obligation to comply with employment law. You might well be familiar with some of those concepts. They need to issue contracts of employment, they need to ensure pay is done on time, that holidays are given, and that any grievance disciplinary procedures are followed appropriately. And also you are required to maintain the standards of behaviour, both for yourself and also for your PAs. You must also protect against discrimination, make reasonable adjustments for any disabled workers, that's somebody who has a physical or mental disability. And of course, you've got to protect against harassment. That's either from harassment which may be occurring because of yourself, because of other employees, or even third parties. So there's a list there of legal must-have that if you've been an employee for any period of time, you might well be familiar with these. The need to issue a written contract of employment. They need to, that says required within 2 months. Apologies, that is actually incorrect. It's by day one of employment now. Job description, you should be issuing one that gives some clarity on the employee's role and what it is that you expect from them in the role that you've recruited them into. Payroll compliance, you must also have your employer's national insurance paid along with any PAYE, and you've got to have your employer's liability insurance. That is legally required. You've got to also go through any health and safety checks, risk assessments. That means you ensuring that health and safety law has actually been met, and if not, getting somebody else in who can do that for you. And of course, data protection controls are also necessary, including a privacy statement, which you can include in your employee handbook. So just a very few legal do's and don'ts. So legal do's, you've got to provide the written statement of terms. That's the contract of employment. Follow your disciplinary procedures well, accurately. Keep records of any meetings, warnings and agreements. Respect PA rights, including things like sick pay, holiday pay, rest breaks, and so on. And ensure your safe working conditions. Legal don'ts is do not ever dismiss without process. You will run the risk of an unfair dismissal claim. Do not pay below the national minimum wage, and that's even for sleep-in shifts. Do not discriminate. So do not discriminate against an employee on any of the protected characteristics. We're looking at things like age, gender, disability, marital status, sexual orientation, gender, reassignment. Discrimination comes in all sorts of different forms, which would be a fascinating session to do with you at some point in the future. I would really like to take a deeper dive into that with you at some other time. And of course, don't ignore safeguarding concerns. Make sure that your reporting is done appropriately, making sure that you do not overreact to issues when a PA has raised safeguarding concerns. That is something that I do see very commonly, and that can get you into trouble. So, one of the things I wanted to look at, I've laid out this first slide here, is implied conditions, and I'm identifying the employee obligations. The next slide will look at implied conditions, which are employer obligations. Now, when I say implied conditions, what I mean by this is that case law has secured these principles as an implied condition of the employment contract, which means all employment contracts. And these duties that I have set out on these slides do not need to be included in any contract of employment in order for them to be a legally binding obligation on both of the parties. And I want to reference these because I think it's useful for you to sort of see what the underpinning of the relationship looks like from a legal perspective. The way that the courts over the years have impose these implied conditions on all employment to say these are the reasonable expectations of both of the parties involved. Because often these are the clauses that do take into account employee and employer behaviours. So the first one we're looking at with the employee is that they have a duty of fidelity. So an employee's got to act in good faith and they cannot compete with their employer or misuse confidential information. An employee is also under a duty to obey lawful and reasonable instructions. Now, this one is really, really critical when we're thinking about employee behaviours, when we're thinking about managing difficult employees. This condition speaks to the very heart of those behaviours. You, the employee, are expected to follow the reasonable instructions of your employer. And you would almost think, well, oh, do I need to make sure that I've got some very, very detailed job description? Should it be in the contract? We get a lot of inquiries on the legal helpline that suggests people think it needs to be written down in order for that instruction to be valid. It isn't necessarily the case. Where the case law has gone on this particular point is to say, so long as the employer is giving lawful instruction, so of course an employee can validly say, no, I'm not going to rob a bank for you. Absolutely not. It would be against the law, and so it's not a reasonable instruction. I'm using a bold example there to really hammer home the point. But so long as you are essentially asking somebody to follow an instruction that is reasonable and within the general scope of their role, then they are under an obligation to comply with that, and refusing to do so would be considered a breach of contract. Whether or not you have some job description that lists activities, that isn't strictly necessary. An employee is also under a duty of care towards you in respect of the role that they are doing. They must have that duty of care towards you, their work, their colleagues, and of course a duty of competence accompanies that. It is no good to simply say that somebody is doing the job. They need to do so competently, achieve the objectives and the goals that you have determined for that role. The next one that's listed here is a duty of mutual trust and confidence. The word mutual is important, and as you'll see on the next slide, it's because it applies to both parties. So it applies both to the employee and it applies to the employer. So you must not act in a way that is designed to seriously damage the employment relationship. So this very much speaks to behaviours. An employee cannot simply say, nope, I'm not doing that. They cannot get shouting at you. They cannot be argumentative. Those sorts of behaviours are going to breach this duty of trust and confidence. And the same applies for an employer. You cannot bark instructions as an employee. You must ask so reasonably and fairly, with some degree of respect and dignity towards the employee. And that way, if you both conduct yourselves in that manner, you are meeting that mutual duty and the relationship will thrive. There is also, on the PA's part, the duty to be honest and act with integrity. So that includes accurate reporting of hours of work, any expenses that they've incurred, and information about their own conduct. On that point, I would say that typically there is no obligation on a worker to report to you their own wrongdoing, which is an interesting quirk of this duty. That the case law has made it very clear that there is no express duty on an everyday worker to report their own wrongdoing, unlike, let's say, a director of a business who has these high-level fiduciary duties. Typically, an employee isn't expected to provide that unless there are clear rules in your own policies and procedures, job descriptions maybe, that state so. But nevertheless, when they are requested to report to you on their own conduct, when they are asked questions, then of course they are under an obligation to be honest and to communicate that to you when it is required of them. So further duty that we've stated here is the duty not to disrupt the employer's business. Now, using this expression business because that's where the case law went. That's what the judges were considering in the cases that have given us this implied condition in all employment contracts. And whilst we're using the word business, of course, it's recognised that individual employers aren't necessarily running any business. There isn't a profit to be made by the employment of PAs. But nevertheless, we can apply the concept of the employer's needs should be met and honoured. There is a duty for the worker not to disrupt that. So I'll give you a little example that I come across quite a lot. Let's say a PA is going out with the person in receipt of support, and they're going shopping. And actually, I was like, no, 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 I don't actually want to shop in that shop you want to go to. I want to go here and I want to go there. And you find that going around the supermarket, the PA is too busy filling their own basket up and not actually supporting the employer with their own shopping. I would suggest that those sorts of behaviours would fall under this duty. You're in breach of this duty. You're actually disrupting the provision of providing for the employer's needs. Okay. So this is just a quick overview then of employees. This isn't a complete list, by the way. This is just the key duties that I thought were relevant to discuss today. But actually, there's quite a considerable list of implied conditions that have come about through the course of time. So now a quick look then at employers' obligations, again implied into all employment contracts. Now the top two here are the fairly obvious ones, let's say, duty to provide a safe working environment and duty to pay wages, things that I'm sure everybody would automatically expect would be included. But these last three, again, speak to conduct, behaviours on the part of the employer. So we've got the duty of mutual trust and confidence that we looked at when we talked about PAs and employees' obligations, that you cannot act in a way that seriously damages the relationship with the employee. Now, that is whether you intend to seriously damage it or not. Even that negligent behaviours that are a third party would consider to be serious and fundamentally damaging the relationship will be sufficient to put you in breach of this duty. So also, some common examples here is unfair treatment, bullying, discrimination, very serious behaviours, but also things that are going to, you're effectively riding roughshod over somebody's rights. So if you refuse to follow a fair procedure, if you refuse to follow your own policies and procedures, that would be an important breach of trust as well. So it really can be in all areas of employee management, whether you're looking at the way in which you draft a contract, the way you manage a process, the way you speak to an employee on a day-to-day basis. You need to keep in mind that your goal is to act in good faith and meet that trust and confidence. And then, of course, we've got the duty to not undermine the employment relationship. So employers need to avoid actions that make it absolutely impossible for an employee to perform their role effectively. So an example here is removing key responsibilities without consultation or support. This is actually quite important because as much as we recognise that PAs are employed to fulfil a certain role for you, when an employer is struggling to tackle a concern about PA's conduct, maybe capability even in the role, they're not doing the job well enough, rather than tackle that and address the capability concerns, it's really common for an employer to sort of try and just avoid it altogether, really, and go, actually, I'm just going to take that off you. Now, things like that, stripping away responsibilities, definitely can have the effect of undermining that employment relationship. So it's important that you're not making decisions unilaterally and failing to communicate, because that can really undermine the relationship between the two of you. So that's just a very, very quick look at implied conditions. We can see that what the law requires of us, whether that's as employees or employers, is to make sure that there is good communication and that we recognise a mutual relationship of respect and acting in good faith. So, having a quick look now at resolving issues practically. I've just listed, we're going to look at about 5, I think, different issues that come up an awful lot, inquiries that we get on the legal helpline. The first one, and probably the most common, is lateness and absenteeism. This can occur for many, many different reasons. It can occur because somebody is sick. It can occur because they have emergency leave for dependents. a right which you may be familiar with, which is for them to take unpaid time off to deal with an emergency situation. For one of their dependents. That could be a family member, a spouse, a child, even somebody who lives next door and otherwise doesn't get support. Or, frankly, it can happen purely because PAs are simply not meeting their obligations under their contract, or they are misunderstanding the degree to which they are obliged to attend and start treating it as a bit more casual, where perhaps otherwise you would take the view, no, this is a permanent contract. They're meant to turn up on a regular basis, and they simply don't. There's all sorts of things that can cause lateness and absenteeism. So practical responses then. The first thing I need to say to you is please do collect the detail of the reasons for that absence on the day, at the point it is being reported to you. I'm really emphasizing this because imagine from my point of view, I get a phone call saying, right, I've got a PA who's very frequently late. She's off an awful lot. One of the first things I am going to ask you for is a list of the absences, but also the reasons. So I want to create the distinction. Was that a genuine sick day? Was that a genuine leave for dependence day? Because if it was a leave for dependence day, then we're going to discount that from any formal proceedings because that worker has a right to take that day. So it's really critical that you have identified what the reasons are on the day itself, ideally, or as soon as possible thereafter. It's also important to note, I haven't put it in the notes here, but something else I'm going to say to you is holiday. It is not uncommon for me to hear that, oh, well, she just took a holiday without asking for it. Well, did she take a holiday? Because a holiday will only actually occur if they've given you adequate notice in accordance with your rules, or if you've approved it. Now, don't get me wrong, one of my team could call me today and say, I've got something has come up and I know it's not normal for us, but any chance you could give me this afternoon, I'll take it as a holiday. And I can choose to approve it. Okay. Now, if one of my workers just simply did not come back from lunch and there's been no approval of holiday granted, I am under no obligation to later on treat that half a day as holiday. I would be treating it as absence without leave. So this is why I'm saying to you, take the detail of the reason for the absence on the day. Be clear as to whether or not you feel it's justified on that day and what category it falls under. So somebody simply saying, oh, I just haven't slept very well. Well, I would be wanting to find out what exactly does that mean? Did you get 1 hour of sleep for good reason? Or were you actually up drinking with your friends? Or what, is it genuinely that you are going through a period of sickness and you are not well? And as a consequence, you're genuinely unfit for work. The reason should be clear to you, as clear as possible. I just spoke to a lady very recently actually who was saying she just this PA she just keeps saying that she's too tired, she didn't get enough sleep. When I asked her how long the shift was, it was an hour. The shift was 1 hour. And so and this lady lives around the corner as well. PA literally lives around the corner. So in a case like that, I would have liked for the employer to have challenged her a little bit. Well, hang on a minute. You're not fit for even 1 hour of work where the work wasn't strenuous. The work was being in attendance with the person in receipt of support to allow mum to go out and do the school run for the other kids. It really wasn't all that difficult. So was that a genuine reason to need to be off? So really emphasizing this point that when it comes to lateness and absenteeism, please do be really confident on the day of the reasons and what category it falls under. Make sure also that the absence is reported correctly. Now, we do put, this is the legal helpline with ILG support, we put in our template contracts a clause that says you must, if you are calling in sick, you must call. Now, that's not going to work for everybody. Some people genuinely can't have the telephone call, and because of their preference for communication, they would rather it be by text. Absolutely fine. The point is that you, the employer, should be able to determine what that communication method is. And if you have said, I need a telephone call, which is reasonable, given what I've just been saying to you about get the reasons, be clear as to why they are off, you can do that so much easier by a telephone call, can't you? In one conversation, you've got all of the information you need. You can ask any questions like, do you think you're going to be back in tomorrow? Whereas if we extend communication about an absence by text message that goes on over hours, because that can be the case. Oh, I hope you're feeling all right. Can you let me know this? You don't hear anything for 2 hours. Then you get just a very brief response. It's not good enough. You still don't really understand. Do I need to get cover in for tomorrow? I don't know. You can be left in this extremely frustrating position where the communication is not thorough enough, and both parties are getting irritated with each other. You're getting irritated because you don't know enough. The employee is getting irritated because they're actually really poorly and just want to be crushed in bed. You know? So if you have said, these are my rules, this is how it should be reported, then make sure it is reported that way. When I get a text message from one of my team, if I want more information, I will say, can you please give me a call? And I won't accept it just by the text alone. But I'm also encouraging the police to note when they have failed to report adequately. Because if at a future date you're going to take more formal action, that alone can be considered a breach. Just the absence itself, but the fact that this PA refuses to follow your reasonable instructions and your work policies and procedures. So do keep a note of that alongside the reasons for the absence in the first place. When we are talking about sickness, it is always sensible to do a return to work interview. This gives you the opportunity to make sure that you have understood the illness, what has caused them to be off work. It gives you the opportunity to identify if perhaps there is a more permanent and underlying condition that maybe could be considered a disability and that you will want to make reasonable adjustments for. But also, and this is a more general reflection, I feel it also creates a sense of accountability. Workers are much less likely to call in sick and have those last minute delay, last minute days off if they know that you're going to scrutinize them, even nicely and kindly. This is not a third degree. You're just going to be sat, possibly with a bit of a form, ask it, how are you? How are you doing? Are you on any medication? Do you feel better now? Excellent, great. Because that discussion takes place and it has become part of your practice, it genuinely does reduce absenteeism. And I have seen this work not only with PAs, but also in larger organizations. As soon as you put in place a slightly more formalized process, it really does make things better. Make sure you're documenting everything to do with your sickness absence in particular, but any kind of an absence. So if you are, as we've already talked about, making sure that you've highlighted the reasons, I'm also going to say keep hold of any evidence. So if you have got, let's say, text messages is very common, or if there are email threads, make sure you're keeping hold of all of the documentation. Where possible, if it's appropriate to do so, then you may need to or wish to offer support to encourage that return to work. And certainly when it's related to a disability, you're going to be much more considerate. You're going to be thinking about reasonable adjustments if that is appropriate to do so. Do take advice on that if you're ever uncertain as to whether or not that obligation is actually upon you, given the circumstances. But it's also reasonable for you to consider looking at patterns of absence. So this is the expression we use frequently is malingering. So this where an employee has developed a pattern. It can very frequently be like a Monday morning, let's say, if they've been too busy having a great time on the town over the weekend, or perhaps a Friday because they want to get on the town at the weekend. Patterns can occur quite frequently, even something I'm using very obvious examples of where an individual is looking to fulfill their own personal desires. But another thing that can happen is certain holidays. You realize that this worker, despite being on shift for Christmas, let's say, really never does work at Christmas because there's always something that comes up. They're not well, or something else happens. Or, of course, it may even occur around school holidays. If when the kids are off, they haven't planned appropriately for the holiday, so you develop a pattern of absenteeism around school holidays. So it's worth having a look where patterns are arising. Also, limit any non urgent or necessary excuses. So by this, I mean, on occasion, I think everybody has a situation where you don't know what else to do. You can't book a last minute holiday unless your employer approves it. You don't necessarily have an an emergency leave a dependent situation, and you aren't necessarily sick. These things still can come up. So I can think of many cases, things, it might sound daft, but my dog is poorly. My dog is really sick. My dog's actually, I don't know what to do with him. I can't just leave the dog at home while he's as poorly as this. I've got to get him to the vet. Now, those usual reasons for you being absent from work don't arise. The boiler has exploded. I've got a situation in my home, or, there really is something where I need this delivery coming to the house and there's nothing I can do about it. I've got to get it done. There may well be occasions like this where we as human beings recognize, well, I get it actually, and I will allow the worker to take that time. But do yourself a favour and try to limit them, or when you are granting those periods of leave, make it clear that it is a one off, that it is because you have seen the difficulty in their situation, and that you're not simply allowing them to believe that this is a permanent thing. Because we do not want your PAs to feel that they have got control over when they can come to work, and when they don't. Make it clear that you are approving them only as a short term. Legal note consistently through all of these is going to be that when a problem gets too far, you need to have good records, and you need to take advice to go through a formal process, particularly before any disciplinary sanction and before any dismissal. Most certainly, there are legal rules as to how you go about doing that fairly, so you should always make sure you take advice. So the second problem that can arise, poor attitude and disrespect. With this one, of course, this can fall under the remit of misconduct, but remembering that mutual duty of trust and confidence, that duty for you both to act in good faith, it is essential that your judgment is appropriate. So if you have been swearing at the employee, if you have been shouting at the employee, then the likelihood is they are going to retaliate. If, however, you have always maintained an assertive but professional tone, then any poor attitude and disrespect should not be tolerated. I am really adamant about this. Now, I appreciate that the challenge, I've heard it many, many times, the challenge is that can be rather difficult when this person is in your own home. It can be particularly difficult when you are not feeling well enough to handle it. Absolutely understood. The closer somebody works with you, the more intimate that relationship ought to be, then the harder it is for you to assert your own authority. But I also believe that it is even more essential that you do so, because they are in your home. They are there to support your lifestyle, to help you to live independently and to fulfill your needs. So you must take the opportunity to tell them when those behaviours are not acceptable to you. But be clear about why. Try not to come across too confrontational, but be clear. I'm not okay with that. The way that you've just spoken, this would be my preference. There's some sample phrases there that may be useful, but you find the way to communicate that suits you. There is no reason why you cannot be clear about your requirements, and you should not feel that you need to hold back. Okay, just don't go shouting, don't go swearing, but be clear. If you need to, you can hold an informal meeting, or you could perhaps even build it into a check-in. If you're having regular one-to-ones, some employers find it really useful to do this on a regular basis. Employees can get an awful lot from it. It's these one-to-one conversations where the whole purpose is to say, how are you doing in the role? How is it working? Is this working for me? Yeah, I think you're really good at this. I could do with you working on that. However, you've got that opportunity to zone in. So if you're able to do check-ins, one-to-ones, appraisals, whatever you want to call it, by all means do that on I say regular, often employers will do it on a 3 monthly basis, maybe even 6 monthly. So if there are bits of conduct issues that are occurring, even if it's only minor, those perhaps might be the time where you can use the check-in to help you to communicate that if you're feeling less confident to handle it in the moment when it happens. Now, if it does come to a moment of disrespect, very tricky thing for me to say, but do try to stay calm. Certainly, you must not do anything that then imposes a detriment on the worker, like suspension from employment, certainly not dismissal. Please do not take any of those actions without taking advice. Now, I've put a little note on the page there to say if you are sending someone home when a situation has become heated, if that ever happens, and I hope for your sake that it doesn't, but make sure it's clear, because it's understandable, you've really heated the moment and PA's behaviour is not okay, it is understandable that you would send them home because you're wanting to avoid a confrontation and from it escalating, which is fair enough, but make sure that in your communication you are clear that it's for now. Please do note that you will need to continue to pay them because it has been your choice to send them home, if that's what you're doing. So you will need to pay them, but communicate that it is only temporary and that you will be in touch. Do not say things like, that's it, you're out, you're gone. It's too generic and it could read like a dismissal. The employee can take it as such, and then we get into a difficult position where we're not sure, was this actually a dismissal or not? So please be clear. Always, when we're talking about poor attitude and disrespect, as you'll see in the right-hand side in the notes there, take the details. Take the details as to when something has happened, what happened, how it happened, and the how is critical. I'm going to give you an example that I was taught when studying employment law many years ago. There is a difference between somebody accidentally dropping a glass and it smashing on the floor and somebody grabbing a glass in temper and throwing it on the floor. The same facts have occurred. A glass has been broken because of something that PA has done. But the first example is an accident. The second example is serious misconduct. It's intentional poor behaviour. So your notes as to how severe certain behaviours are is extremely useful should you later on want to take advice and to take formal disciplinary action. Okay? Please do be as detailed as you can. You want to paint the picture. Now, these are some other issues that can arise, perhaps less frequently than the first two, which is why I've perhaps laboured those a little bit more. But over familiarity can also be a problem with PAs. They are coming into your home. They are possibly getting a little bit over um, conscientious, let's say, feeling like they want to almost mother you and take the decision away from you. That's not okay either. So it's always reasonable for you to be reminding them of their job scope, any job description they may have. You can also communicate your own personal boundaries. Do express that. Remember that you can go about this role of employer by being friendly without necessarily being friends. Many cases I have spoken to employers about, we can see, and the employer admits that they fell into the trap of being friends instead of maintaining that professional but friendly approach. Um, if we think about what a friend is somebody who perhaps can be a bit cheeky with you, can go, oh, can I just borrow this? They might walk into your house and put the kettle on when they feel like it. They, they've got the boundaries are broader with somebody considered a friend. Ideally, with a PA, you want to maintain the professional boundaries. Yes, we will be friendly. Yes, we'll have a bit of a chat about what's going on in our private lives. But you don't want it to go so far that it takes over them fulfilling what you need of them in that job role. It is totally reasonable for you to recognize good ideas and a conscientious approach, but make sure that you are maintaining your own decision making in the moment. So, yeah, great, I hear you, that's fabulous. However, this is what I would like. This is the way we're going to do it today. Do not be afraid of ensuring that your needs have been fulfilled in that moment. And most certainly, whatever you do, do not descend into arguing. For one, of course, I'm going to say don't descend into arguing because we don't want to encourage or, let's say, risk you being in breach of your duty of that mutual trust and confidence. We don't want you shouting, we don't want you swearing at them, of course not. But I give this piece of advice not just for that reason, but for the second reason, which is you're the boss. They can't argue with you. So long as you are giving reasonable instructions that are lawful, there is no argument to be had. It is your decision. If you want to do things a certain way, then you do it that way. There is no argument in it. It's a moment of assertiveness. I hope that makes sense. Arguments play no part in it. And if you allow that kind of behavior, then it is more likely to happen moving forward. I always had that same attitude bringing up my son. It's like, no, you're not arguing with mom. It's the same principle with your employees. Breaches of confidentiality. The first thing I'm going to say on this is please do note that not everything that may be sensitive to you would naturally fall under a confidentiality title, let's say, as far as an employment tribunal is concerned. So ideally, you want to make sure that you've got your privacy policies, you've got your confidentiality clauses drafted if there is something that is particularly sensitive to you that's covered. But somebody talking about, the day-to-day, the fact that they work for you, is not in and of itself going to be a breach of confidentiality, and it's certainly not a breach of confidentiality if they are sharing with their spouse and their family that they're in trouble with you. But it would be considered a breach if they were going about town and sharing with everybody in the village everything about your medical condition. So we've got to be conscious of what is confidential problems in the first place. So having good policies in place is a good thing. Discussing with them, retraining them on your privacy needs, always good to know, good to do. And then if further action needs to be taken, and it can be serious in some cases, do seek advice, and disciplinary procedures may be necessary. Refusal to perform tasks very much falls into the same sort of principles that we've just talked about with a poor attitude and being rude. It's the same principle in that we can, of course, go back to revisiting the job role, any job descriptions, and of course your own workplace policies. You can assess whether there is a need for retraining, consider any insecurities or underconfidence if that perhaps is feeding into the PA's refusal to perform. Are they simply underconfident, don't fully understand what's needed of them? Absolutely critical. Ensure that your instructions are clearly communicated. Do not leave it open. Nobody has the crystal ball. Make sure that you have told them what you want. Sometimes it can be something silly. It can be, I like when somebody is dusting the shelf, I like them to lift the objects and dust underneath. Now, I am not giving you this example because I'm making it up on the spot. I have literally had this inquiry from an employer who has said, am I being over, my employee just won't do it. And this is the way I like it to be done. Of course, it is a reasonable instruction. It is not unlawful, and therefore your PA should do it the way you wish them to. So make sure that your instructions as to how you like that cleaning to be done, taking this example, and running with that, make sure it's clear what it is that you want, and then follow that through with them, pulling them up whenever it has not been done correctly. Fundamentally, if we continue to have this refusal and their refusal is unreasonable, and it is not because of skill set, it is just simply that their behaviours, their conduct isn't acceptable and they're refusing to do their job, then of course we can move forward with formal disciplinary action. Please do take advice. So just a few notes on when to seek help. Of course, you've got a payroll company and it's a matter of payroll. Do speak to them. Any support organisations that you have, colleagues, the community, speak to them as well. Funding queries, make sure you speak to your direct payment support team or your social worker. For legal advice, it is absolutely critical, especially for things like your complex dismissals or any safeguarding issues, where an employee has raised them. Do make sure that you speak to your legal helpline that's included with your employer's liability insurance policy. I've put a little list here of occasions where it's important that you do speak to the legal helpline. What you'll see there is the common thread before. It is important that you speak to your legal helpline before taking any action, basically, which is likely to cause a detriment to your worker. One of the reasons, of course, if there's the practical, we will help you to get through a problem before it becomes a bigger problem. We want to avoid you running the risk of getting into a true legal dispute. But also, secondly, it is because most legal expense insurance policies, which are included in your insurance product with your employer's liability provider, whomever that may be, a legal expense insurance product says that you must have taken advice from the legal helpline in order for those later legal costs to be covered. So for that reason alone, check in with your legal helpline provider. Okay. I put a little note at the bottom saying, please don't take employee management advice from your social worker. I am sorry for any social workers who may be in the audience, but we've had a number of cases, one very recently, where a social worker has gone, oh yeah, it's fine. No, that's not okay for your PA to behave like that. Just go ahead and dismiss them. And actually it was not good. The PA was over 2 years service. Do not get me wrong. That is, the PA's behavior was not okay, but they had completely skipped the process that is necessary for a fair dismissal. And, I think it's important to say that social workers are not legally trained. Yes, they are really tapped into your welfare and making sure that you've got the right support in place, but they don't necessarily know how to go about dealing with an employee issue. So please do be a little bit vigilant on that, not assume that because they're a professional, they know absolutely everything. Speak to the professionals who really do have the experience that are needed for that particular inquiry. So just some closing tips. think of your PA relationship as a professional partnership where you can. Clarity, consistency, and some compassion absolutely go a long way. Document everything, it protects both parties. And ideally, deal with things in the moment. Don't wait for the crisis to arise. Be proactive, handle things in that moment. And of course, if that doesn't work, take advice when needed. Okay, and that's me done.
Thank you so much, Rachel. We have, oh no, it wasn't meant to do that, meant to pin us both up. There we go. We have had a lot of questions in the chat, so I'm going to try and get through as many as possible very quickly, if that's okay. But that was absolutely fantastic and so helpful, so thank you so much. I'm not necessarily going to do these in order. I'm going to put some of the more complicated ones towards the bottom, but so don't worry that you've been missed out. I think I've got them all. But in terms of duty of fidelity, what would competing with their employer look like?
For individual employers, I often feel that it is where there is a conflict of interest in terms of working for another worker. Often your PA may well have, let's say you've agreed a contract with them where you are to put them on flexible hours. Maybe your process is to have them on a rota system, and then next week they're not attending because they've got a shift somewhere else. That is breach. That's a conflict of your interests. If they're not able to honour their contracted terms, then it's not acceptable. And more broadly in the world of business, it's going to be things like, sharing data about customers and the likes. Now, of course, that's not relevant, but where it fundamentally conflicts with the purpose of their role, that's where that duty of fidelity can be seen to have been breached.
Lovely, thank you very much. The next one, someone's just had a self-employed PA who's only been there for a week and has now announced that they're pregnant, and they were going to tell her in a few months, but she's 12 weeks already. The job is quite hands-on and involves lifting. What should she do from here?
Okay. I've got to say to you, speak to your legal helpline. That is a very specific question. One of my immediate concerns on this is genuinely to what degree is this person genuinely self-employed? Because employment law doesn't apply to self-employed. If they are truly, truly self-employed, then whatever terms you have agreed with them, imagine if they were an agency, for example, your terms that you have agreed with them is a contract for services as opposed to of service, which is what an employee is, that's what's going to apply. So you're probably not going to be looking at maternity rights, maternity pay. You can simply say, well, send in somebody else to do the job then if you can't do it. But the assessment of whether or not somebody truly is a self-employed worker or an employee is my immediate concern, because what you don't want to do is assume they're truly self-employed and fall foul of employment law later on down the line. So please do take advice first.
Thank you. We've had quite a few questions on self-employment, so if it's okay with you at the end, I'm going to add David to help answer some of those because there's been some quite specific things.
Sure.
So just carrying on with the normal questions. So what it's my understanding coming in soon or even now that the right to unfair dismissal starts on day one. Has that actually come in yet, or is that coming in?
No, it's coming in, and I think
Coming
there are going to be changes. So we're still looking at the Employment Rights Bill is
in.
the bill that's going to be making some significant changes. We were told that changes were going to come in 2026. It looks likely that it's now going to be 2027. At the moment, it's still a little unclear, but my understanding of it is that there's effectively going to be a statutory probation period. So, a period within which the law defines as being a trial for the job. So, during that period, a dismissal will not be unfair. Anything outside of that, it will be. And what it certainly means is that that 2-year period we've gotten very used to having in England is going to be reduced. We're more likely to be looking at either 6 months or 1 year depending on the way it goes. It's still working its way. It's finished in the House of Lords now, is our understanding, and it's now gone back to the Commons. So we've still not yet got to the final place. We don't yet know exactly what it's going to look like, but it most certainly is going to cut the time frame down. So that is really important, that with all of your PA management, you get onto it. Don't leave things lingering. Like we said, that last slides, like, don't wait for it to become critical. Deal with the issues in the moment, and then you avoid the risk of having later on to take long-winded proceedings. If you could have done it sooner, that's what you want to do.
So the question was going to be around what happens if a PA starts and you just don't click with them. So as opposed to them doing anything wrong, just sort of personality, but I guess that probation period will still be there. It will just be more limited.
Absolutely.
Okay.
Probation period is still going to be there. It's just going to be rather done on much more of a statutory basis. One of the things to keep in mind, you see, with employment law is, unlike classic contract law, which is, it's whatever is the agreement between two parties, they're free to negotiate. Certainly business to business are free to negotiate whatever they like, so long as it's not unlawful. Employment law is much more regulated by the state in order to ensure that commerce operates fairly and that employees are also treated fairly. So that's why we deal with so much regulation and interference, you could argue, from the government. But yes, a probation period is still recognised as being important to make sure that those relationships are working out. The government still wish for employers to have a fair opportunity to truly consider if an employee is right for them. And so long as you're not discriminating, yes, let them go during that period of probation.
Okay, thank you. Right, so for someone else, I do realise it's 3 o'clock, by the way. Have you got a few minutes just to answer
I'm okay.
some more? Yeah, okay, lovely. So her PA arrived with a bandage on her wrist and only mentioned not being able to carry shopping. The PA didn't ask for any other adjustments, but the client then felt unable for them to do other normal tasks like put the bin out or push her wheelchair. How should the employer have handled this?
It is a challenging one. I think in a moment like that, I would use your own obligation to risk assess your health and safety obligations that we mentioned earlier on in those slides. Use that as your mechanism to open the conversation with the worker. I need to make sure that you are safe and I can see you are injured. So I need to be confident I am not asking you to do tasks and activities that you're not safe to do. And that would allow you to discuss it further. Of course, the consequence is also going to be that you're protecting yourself. You're not having the worker do something that's potentially putting you at risk. But it's a great way to open that chat, isn't it? If you're feeling otherwise awkward and you don't want it to feel a bit me, there's a great way to say, actually, this is about you too.
I would just add on that though, sometimes by protecting yourself, it means you're not protecting yourself. And by that, I mean, I've actually been in this situation before. And what happened is I did the things as the employer I shouldn't physically do, and I got injured. Because I felt uncomfortable asking her to do it, sort of thing. So it can be a really difficult situation, especially if someone is there to do those physical things with you. I know there's no easy magical answer to this, but yeah, it is a really tough one to sort of, you know, to decide who comes first here. And obviously, as the
Yeah.
employer, you've got to put them first. But yeah, it's tricky. So what can you do if a PA does keep breaking things, but not intentionally, but due to rushing or not thinking the task through?
I feel that that is still something where ultimately a disciplinary process can be used. It can be appropriate because, like we saw with that implied duty of competence, you are not paying somebody to be cleaning your house, let's say, and they're going around smashing every ornament that you've got, even though it's mistaken. It's, oops, I'm so sorry. It's still not completing the role with competence. There is a duty of care owed by that worker to you. And if they are causing damage, if they are causing injury to you, if they are not fulfilling their role in a way that is competent and safe, then yes, you can take action. Now, depending on the the nuances, the facts of the case, on the one hand, you could consider a capability process. On the other, it could be actually its conduct, because there is a genuine lack of care, an intentional almost lack of care, which tips it more into the conduct space than it does capability. But either way, taking the right advice, you'd go down a proper process. I do think that that is something that can be addressed. Please, again, as I've been saying through this whole session, take your notes, make sure that you've got your evidence together. Things, if you're talking damage, let's start taking photographs, collect your evidence together, because it makes it harder if it's just you telling a story that you vague recollection that 6 months ago something got broken. Make sure you're taking your notes and collecting your evidence at the time.
Lovely, thank you. So this question is around advice regarding injuries to staff in the course of their employment when supporting an individual with behaviour that challenges. And she states this keeps her awake at night, so it's a real stress to her that her son's PAs are being put at risk. Have you got any advice in this kind of situation?
I think it's absolutely critical that you have thoroughly risk assessed. Um, there is a protocol to go through. We at ILG support at least have a handbook, a health and safety handbook, and in that handbook, once it's talked about risk assessments, it's saying that your goal there is to identify hazards, and then there is a list of different things that you should consider in order to address that hazard. So reduce the risk of the hazard causing an injury. It's laid out in health and safety law. And it goes everything from, can you avoid that hazard full stop? Can you remove it? Can you replace it? Can you eventually going on to things like training and PPE? So it's really important that you're following your health and safety practices. And in doing that, you should have a clear understanding of what you can do in order to help. So, it could be the training, it could be the working practices, that whatever has been identified, and make sure then that you follow that through. Now,
Thank you.
something I am going to say when it comes to health and safety law is it says that both the risk assessment in the first place and also any training that is later done in order to help keep people safe has to be done by a competent person. And a competent person is not defined in the law as somebody who has got some, fancy health and safety qualification. It's defined as somebody who has got skills, who has got knowledge, and who has got experience. Now, I'll be really honest with you, I have never had to work with somebody with challenging behaviors. So I know I would not be a competent person to help identify what those hazards are, what the triggers are, and how to keep a team of people safe. I wouldn't do the risk assessment. So be really aware of that. If that is you, if you're kind of like, actually, I don't think I do know, then call in somebody who does. And if you need the funding for it, then apply for the funding for it. If for some reason the funders won't give you the funding to get this additional support, speak to your legal helpline. I know I certainly would be more than happy to draft a snotty legal letter to say this is why you must do this and you're under an obligation to do it, and hopefully that will encourage the funders to pay up.
Thank you. This next one's a really interesting question, which is I have a strange issue that our PA keeps wanting us to be grateful for their support. They constantly say things like, I hope you appreciate this, and things like that. And I'm finding it really odd. And I don't like the feeling the PA is expecting us to be constantly thanking him for his help. Any advice in this situation?
Yeah, it's an interesting one because it's not uncommon, and I'm finding it more and more common. Maybe I'm conscious that I don't know, maybe of a particular generation where with your work ethic, you just expect it to be just part and parcel of somebody taking a job and being paid for the job. You would think that paying them would be enough, but unfortunately, it's not always. And we're certainly seeing a change in employees' attitudes generally as each generation goes by. It's something that's reflected on quite considerably, actually, in the world of HR. that what people want from their roles is changing, and pay alone isn't enough. They do want to get that recognition. They want to know that they're actually doing something good. They're more likely to want breaks from the job as well, even that, old-fashioned way of you go to school, then you work, then you retire, and that's your life broken down into thirds in that way. Even that's changing. People are much more likely to take career breaks and also not really retire at all. It's just breaks throughout the course of the life. Everything changes. And I'm reflecting on this to sort of say, I really totally understand how irritating it is, but make sure that you're keeping some balance. You recognize that actually we are talking about care workers who want to do a good job. At least I would hope that's the reason that they're asking. In terms of the practical management of it, don't be afraid to once in a while say, great job, oh, thanks for that. That may really made a difference. Or even maybe employ that checking in process, the one-to-ones, maybe every quarter. You can have your check-ins. So hopefully that will help the worker to feel like, oh yeah, I'm getting the feedback that I desire. If it's really genuinely too irritating, then it's like I was saying before, don't be afraid of expressing your own personal boundaries. Reminding them your job is about providing for my support needs, my daily needs. And I will give you the feedback, I will give you the reassurance that you need, but it's a bit much. I need you to just step back a little bit from your requests for it.
Thank you. I know what you mean about different expectations. Sometimes I remember, and this isn't about thanking people, but I remember I took on quite a young PA once, and it was her first week, and she texted me a few minutes before the shift, "Oh, I can't make it today. I'm meeting a friend," and I had to say, "No, that's not how this works. This isn't a
Mm-hmm.
come when you can. This is your job, and if you
Yeah,
want to take leave, annual leave needs to be agreed in advance." And it just
exactly.
didn't occur to her, like, surprise, surprise, she didn't last long, but that's and that's not casting a thing on all young people. We've had some fantastic young PAs too, but just
Yes,
sometimes there's just different thought processes going on.
yes, yeah.
Um, okay, right. So the next couple of questions, I'm going to add David in now, um, because there's two different ones which I think both of you will have a view on. So a lot of you would have seen Max has been putting quite a lot in the chat. Unfortunately, they've had to go now. But around the fact that it's something that David and I have often spoken about as well. And it's this kind of expectation on employers, that irony that one, you're disabled enough to need this help in the first place, but then you have to become an employer in the other side. And it's an enormous amount of work. I'm just reading from the comment now. And admin and the management of a team is a full-time job within itself. Essentially, the councils are saving money, making us do this work for nothing. They should really allow us to employ an admin person to fulfill these duties of our packages. And then it's more about the employment law, and management is a nightmare and so volatile. I don't think the current situation is appropriate or satisfactory at all. So I just thought, it'd be interesting to get both of your views on this. This kind of this expectation that us as individual employers are being held up to the same standard as a, Fortune 500 company with an HR department, etc. And I know there's no, the answer is we are, but I guess just more thought to that would be interesting. Do you want to go first, Rachel, and then David?
Oh, it really is a challenge. I mean, there's a couple of things that sort of hit me immediately. The first one, I would say, when it comes to the funding point that's been made there, I agree. I think if you have a significant team of people, there should be an expectation that somebody else can take more of a senior role, more of an admin role for you. I actually really fundamentally agree with that, and have spoken to people over the years where that is exactly what they've managed to negotiate with their funding body. Um, and the other one is the whole sense that employment law and all other legal obligations apply equally to individual employers as they do with any other business is a really difficult one. It's a really challenging point because I see the benefit to protecting workers. Already there is care work is very difficult for you to recruit in. It's a role where they get paid insufficiently. Good carers, in my view, should be paid more. They should get better benefits. And it isn't really an appealing role to go into always. I think that we should be doing more for them, and therefore they should be protected when we've got the good ones. But on the other hand, I also constantly, daily see the challenge of trying to apply employment law to a non-business environment such as PA's work, and it is a challenge. I wish I knew what the solution was, and it's a constant debate that I have got, and one I've even written essays about. Employment law is getting in harder and harder and harder, actually, with the Employment Rights Bill and other provisions coming along. It's only going to get more challenging. Employees' rights are going to consistently grow. I feel, if anything, the community should come together and sort of campaign for tweaks and adjustments, and hopefully get the legislators to listen. But
That's interesting you say that about tweaks and adjustments, because we've had this conversation quite a lot, haven't we, David? Whereas I do feel there should be not necessarily a total exemption from everything, but more of a just an understanding in the legal system that, you know, we aren't the same and it is added difficulties for us. And you've kind of felt that that couldn't be done or wouldn't be done, I guess, wouldn't be done, I suppose. What's your sort of view on this?
I think the issue stems. Direct payments is an imperfect system. I think if you look at the origins of direct payments, it was a way of breaking out very, very restrictive ways of providing care and support. Personal assistance as a concept, you know, was about people employing people to support them to live as close to, you know, normal life and independent life as possible. I think that the government have run with direct payments because it's a cheaper option for them. And I think that's very much the driver behind direct payments. I think that in many ways it's veiled with this kind of, this is a better option for people, which of course it is. But if you look at the fact that it is, there are studies to suggest it's better economically for local authority funding bodies, backed up with the fact that even when they offer a direct payment, they're actually measuring their success on the amount they claw back. So I think it's very clear to me that what's needed if somebody has a direct payment employer personal assistant is adequate resource to pay the PA properly, adequate resource to be supported as an employer. So when I started in direct payment support, the number of people that were paid a good salary to support someone in a given area was probably 5 times what it is today in terms of the resources on the ground to help people. And you just had younger physically disabled adults who would employ personal assistants. It's now been since then been rolled out to every client group, including people who lack capacity, with a reduction in the amount of support. So for me personally, I don't think employment law is the problem. I think the problem is the support surrounding people that isn't adequate, the resource isn't adequate, and I think it does put all the pressure on you to try and manage. And I think that comes through in some of the chat today and certainly the conversations we've had in the past. I think, as I put in the chat, there are regulations in the direct payment regulations in adult social care that facilitate you being able to pay somebody, a close relative or somebody else, to help you manage your employment responsibilities. It's very, very rarely realised. It's very rarely agreed, despite it being in the regulations. So for me, I think we have to be very careful about diluting employment rights. Rachel touched on it. I think that rights, we could all be the workers one day, and I think the rights need to be sacrosanct and just as and protected in the same way as your ability to live an independent life is. And I think it's a bit like pitting one side against the other when actually it's kind of look at each other, when actually you should be looking over there at the funding bodies and the politicians who have the power to make decisions to resource things properly. My view would be that's where we need to turn. PAs and employers unite, direct at the people who can actually make that political decision to change it, rather than, you know, trying to change the law necessarily for a small group. As much as I can understand that, how helpful that would be, I think if it potentially, you know, employment rights are hard fought and hard won over the years, and I would be worried about anything that directed the solution there, when actually the solution, I think, is resource and political will.
And of course, the other side of it is, if there is an exemption for PA employers, it could make being a PA even less
Appealing, yeah.
appealing than it already is, which is something we struggle with recruitment. So yeah, it's definitely something. It's very difficult to juggle on both sides.
Yeah.
We've got one more question, which So sorry this has gone on so long, but it's on your favourite topic, David, on self-employment. So we've had a statement put in the chat and then some discussion about it. So first of all, somebody had put that they've been seeing a lot of issues around self-employed PAs, and that the government are looking at banning us from using self-employed PAs in the future owing to all these issues. Now, I don't think that's the case, but there are obviously, and then I just want to read the next response before you jump in, which is, the council here is extremely strict with using self-employed PAs. They need a DBS check with ongoing proof of ID, right to work in the UK, the UTR number, letter from HMRC, you know, all ticking all the boxes. One thing I thought was interesting that they stated that after each session, the self-employed PA had to write a summary of work that they did in a letter for any audits. I've not heard of that before. The rest, yes, making sure that, you know, they're definitely legal, that they, but anyway, before I babble on, I just wanted to get your views on this, on I know it's again, self-employed PA, full stop question, I don't know.
I did put something in the chat earlier to that point, but there is, I mean, a couple of things just to put it to bed. There's no government initiative to ban self-employed PAs. That's absolutely not the case. What is happening is there is a big piece of work, which I know we spoke about before, which the head of employment status from HMRC, Low Income Tax Reform Group, TLAP, National Direct Payments Forum, CQC are now looking at it, Department of Health and Social Care. Those groups are working, which we've actually chaired. So ILG Limited, not ILG Community, and myself personally have chaired lots and lots of meetings throughout a long period of time, trying to create some case studies with community catalysts who are involved. You might know them, all the kind of key people. And really what's happening is that you can be a self-employed PA, but the path for legitimacy is narrower than it appears. And the reason for that is because, for the stuff I put in the chat, in order to be self-employed, for a slam dunk for self-employment, you used to have an unfettered right to substitute yourself. Now, nobody in their right mind who wants a PA is going to be satisfied if their PA says, I'm not coming in today, I'm sending in someone else, and that's that. Because that isn't how it works for anybody who wants a PA. You want there to be a degree of choice, at least, about who they replace themselves with. So that's problematic. It doesn't mean without that unfettered right, you can't be self-employed, but then you've got to have all the other things that come with self-employment. You're going to have multiple clients. You're going to have control about how, when and where the work is done. You might take a financial risk. You're running a business. So all the things that we associate with using a PA, choice, control, knowing who's coming, flexibility, continuity, you're diluting them quite significantly if you use Rachel said it earlier, a genuinely self-employed person. The reality is we've got lots of people who call themselves self-employed or are self-employed for tax, who are, if they were examined, would probably come out the other end and there'd be a question mark at best that would say undetermined. And there is a tool, there's a HMRC CESS tool, checking employment status for tax tool, which I've recently actually done lots of work on. And absolutely, if you answer the questions honestly with what most people would describe as self-employed PA, it does come out either undetermined or you're not self-employed. So that the big problem we've got, and I think because I think the thing in the chat about the government coming down on it, I think I know where that's come from, and I understand that why they've said that. The big issue is that enforcement around employment status is lacking, is inactive. So HMRC are not enforcing these rules and regulations that you will find if you do any reading around their own manuals, HMRC manuals, it will say exactly what I've just said in many, many more words. And any guidance you find will pretty much say the same thing. So enforcement from HMRC end is inactive. And the other way of enforcing employment status is a PA has to enforce and claim, their employment rights. And we don't see that enough. Rachel will tell you we've got a case in ILG at the moment, ILG support, where somebody is enforcing their employment rights, has gone to ACAS and made a claims employment tribunal. But that's one in a kind of one in a million, really, who's actually taking it that far. It needs someone to take it that far in order for that to become a case to be examined by the tribunal. And we're pretty certain we know what the outcome will be. But because we've got inactive enforcement, we've got a culture that kind of, it makes it easy to assume, well, nobody's telling me this is wrong. The local authority are telling me I can use self-employed. So I think the guidance hopefully will change that and start to change and turn us on a corner a little bit. But yeah, I think the best thing to apply in your own personal situation, which is as Rachel's alluded to already, and we've said over and over again, is if look at the situation, the relationship determines employment status. The way you want that relationship to work and does work determines what their employment status is. It is not a choice. And I think that is one of the biggest mistakes people make, is to say, because I think somebody actually said it in the chat today, I use self-employed as a workaround, which is what stimulated me to write something in the chat, because you can't do that. In law, you can't do that. You can do it in practice, and nobody's going to come and knock on your door and tell you it's wrong until such time as there's reason to. And that's the risk. So it's not to be the big bad, don't do it. It's just to be, if you do it, there's a risk attached, I think. Does that help? Sorry, I've lived and breathed it for too long, as you know, employment status. So I'll be glad when I can have a break from it. Oh, you're on mute, Jade.
Yep, sorry. That's why you're the perfect person to ask this. But Rachel, have you got anything you'd like to add from your side on self-employment, or you think David's covered it?
No, I think David's covered it. It really is that just please be aware that somebody saying they are self-employed does not mean that they are self-employed. The law operates in a different way. It will analyse all of the facts of the actual case, and the more reliant you are on that worker on a regular basis, and they're taking instruction from you, you're in control, they're turning up to work for you on a regular basis, not even working for other people, the more likely it is that they are not going to truly be considered genuinely self-employed. And that's where the risk comes from. It's your failure to have adequately labelled the employment.
And I'll just, that's perfect. I'll just add one really quick thing, Jade. Sorry, I know it's gone on. Be mindful. One other big thing that's come out of the work we've done is it's on an assignment basis. There's no self-employed PA factory that someone can go in one door and come out the back and they'll forever be self-employed. It's the arrangement they have with you. So it may well be that they're genuinely self-employed over there with somebody else because of what's happening there. But don't assume because of that, and they've got all of the paperwork, that they'll automatically be self-employed with you. Because if you treat them like an employee in the way Rachel described, then they'll be employed by you regardless of what's happening over there. And I think that's quite important because there's a lot of myths around that, I think, that don't help.
Thank you so much. I just want to say thank you so much to both of you, particularly to Rachel for that absolutely fantastic presentation. For all of you, this has been recorded and will go up on our website if you give me around a week for it to go up, because there was a lot of information there. The slides will also be on the website, so you'll be able to sit and read them in your own time and digest them and have a think everything through. But I just wanted to say thank you so much for coming, and to Rachel for giving up her time for free to come along to share all this with us. It is so very, very appreciated. And thank you, David, for all your advice on the self-employed things. It's such a complicated issue, so it's really, really hard to get your head around sometimes. But we've got other events coming up. Again, I put them in the chat. It'll be brilliant to see you all there as well. And thank you so much.
Thanks, Jade. Well done, Rachel. Thank you.
Thanks all. Thank you.